Welcome to the penultimate lecture in my series based upon my book, Artificial Intelligence, Neurodata, and Society, Law at the Edge of Cognition. Chapter 8 brings the book's arguments together around the last private space, the conditions in which thought forms before it becomes action, speech, or data the law already knows how to regulate. The chapter's concern is not a fantasy of perfect mind reading. NeuroAI can govern cognition through ordinary traces, probabilistic models, and adaptive environments. It can infer fatigue, hesitation, cognitive drift, or susceptibility and act upon those estimates without ever asserting a diagnosis or issuing a formal decision. Freedom of thought, therefore, faces a challenge different from overt coercion. The environment can be reorganized around what the system expects, making some options easier, others harder, and the influence itself difficult to identify. This lecture examines why classical rights assumptions strain, why Neurorights remain incomplete, and how prediction becomes cognition formation, and what regulation would have to see to preserve meaningful freedom. It's the book's culminating move from mental privacy as secrecy to cognitive freedom as the preservation of conditions for meaningful self-direction. The classical model assumed that inner thought remained private because it was inaccessible. Freedom of thought protected the forum internum against coercion, indoctrination, and compelled belief. NeuroAI does not necessarily breach that interior directly. It models the traces and trajectories that correlate with cognition, then changes the world around the subject. That's a different form of power. A system need not know the content of a thought to infer when attention is weakening, when impulse control is strained, or which option will feel least effortful. It can preempt deliberation by reordering salience, timing, and friction. The slide's final line captures the doctrinal gap. Freedom of thought protects strongly against intrusion, but law has much less vocabulary for preemption. The question becomes ecological. Does a person remain cognitively free when the environment is continuously adjusted to the inferred contours of their mind? Preemption is harder to name than intrusion because the subject encounters a conveniently reorganized world rather than a recognizable trespass into mental content. The classical assumptions fail in combination. First, opacity no longer guarantees protection because cognition can be modeled indirectly. Second, interference may not appear as an identifiable act. It accumulates through small adjustments. Third, coercion is too narrow a trigger. The system can preserve formal choice while creating asymmetric ease between options. Fourth, conventional remedies arrive after a decision, disclosure, or harm, whereas NeuroAI may shape the conditions that produce those events. The legal imagination therefore looks in the wrong place. It searches the mind's interior for intrusion, or a decision point for a violation. Power has shifted into the surrounding architecture. This does not mean every personalized interface violates freedom of thought. It means that legal analysis must examine duration, adaptivity, inferred vulnerability, and the objective governing the environment. The relevant distinction is no longer simply free versus compelled choice, but choice formed within conditions designed to stabilize a predicted outcome. The cumulative interaction among these assumptions explains why piecemeal doctrinal extension can miss the systemic character of inference-mediated influence. Neurorights remain necessary because they affirm the importance of mental privacy, integrity, and cognitive liberty. But the chapter argues that they are insufficient and partly misdirected when they focus too closely on extraction from the brain. Direct collection is only the gateway. The deeper architecture includes training, pattern stabilization, proxy inference, feedback, and application across domains. A model trained on neural data may later operate entirely through ordinary behavior. A protected signal can disappear while its cognitive meaning survives in the model. The object of protection must therefore include the cognitive environment and the chain of institutional uses. Rights must ask not only whether data entered the system with consent, for example, but whether learned inferences are repurposed to shape opportunity, credibility, price, risk, or access. Protecting the brain while ignoring the modeled shadows of cognition leaves the most scalable form of power untouched. The chapter consequently relocates Neurorights from the point of extraction to the full social life cycle through which cognitive knowledge becomes institutional action. Roberta never received a diagnosis or a refusal. Certain insurance options simply failed to appear. The model has learned from behavioral traces such as slower comparison, longer hesitation, and more deliberate email response. Those patterns may correlate with future cognitive decline, yet Roberta understands them as care, experience, or reflection. The system sees across populations and time. She sees only her own life. That asymmetry produces what the chapter calls latent cognitive truths, probabilistic knowledge about a person's future state that the person may not know and may never accept. The inference is portable. A relationship learned in healthcare or research can travel into insurance, employment, or service allocation without another act of neural measurement. Accuracy does not cure the problem. A highly accurate inference can quietly remove options and reshape life chances before the subject encounters a claim to contest. Insight becomes harm when institutions embed it within a choice architecture. Nothing needs to be inaccurate, discriminatory, or malicious. The injustice can lie in allowing an unannounced probability to become the architecture of another person's opportunity. The matrix, you see, makes an important distinction. Harm does not track predictive accuracy alone. Accurate early detection in healthcare may support optional care while preserving contestability. The same accuracy in insurance or employment can pre-allocate futures and remove opportunity. Even a lower confidence score in policing can produce severe consequences when tied to coercive power. The threshold occurs when a system acts differently because of what it has inferred, and those actions feed back into the person's behavior. Prediction becomes part of the world. The chapter calls this cognitive conditioning by inference, or inference-mediated autonomy erosion. The system does not persuade with reasons or compel through force. It repeatedly adjusts options, timing, and expectations so that some actions become more likely. Feedback can help the original prediction come true. The legal object is therefore not a single score, but the recursive loop through which an expectation becomes an environmental condition. That recursive structure is where knowledge becomes governance, because the system's response changes the evidence on which its next prediction will be based. NeuroAI also unsettles two foundational legal ideas. The first is truth-finding. A score does not accuse in the conventional sense. It anticipates. It can direct investigation, color credibility, and structure pre-trial decisions while remaining outside the witness box. Epistemic authority relocates from claims that can be tested to model credibility established elsewhere. The second is the rational actor. Law attributes consent, intention, and responsibility at identifiable moments. NeuroAI operates longitudinally, shaping habits, salience, and effort before the legally significant choice occurs. The person retains capacity to resist, but resistance becomes asymmetrically costly. Formal agency survives, while its conditions are engineered. The chapter does not embrace determinism or abandon responsibility. It asks the law to distinguish between the formal availability of choice and the substantive configuration of the decision space. Without that distinction, legally valid consent or intention may legitimize outcomes that systems carefully prepared in advance. The legal fiction remains indispensable, but its legitimacy now depends upon examining the environments that distribute cognitive effort, friction, and practical possibility. So Chapter 8 concludes that the AI Act's difficulty is less a coverage gap than a lens failure. Conventional risk regulation looks for discrete systems, intended uses, event-based harms, and malfunction. NeuroAI produces effects through ensembles, inference chains, secondary cognitive use, and successful optimization across time. Regulation would therefore have to see four things. First, recursive inference chains rather than isolated outputs. Second, the movement of cognitive insight across contexts, even when data does not travel. Third, prediction as intervention when infrastructure acts on expectations. Fourth, procedural rights around being inferred about before any formal accusation or decision occurs. And finally, the final scenario preserves a modest but vital reminder. Human action never resolves completely into prediction, and freedom depends upon friction, delay, and genuine opportunities to do otherwise. Don't forget to check out the next video in the series, the final video, where we turn to the epilogue and draw together the book's final argument about cognitive freedom and legal imagination. Regulatory stewardship must preserve the unmeasured remainder by protecting spaces for hesitation, revision, and resistance, rather than treating every deviation as noise to optimize away.